What is the true impact of non-compete agreements? Imagine working hard at a company, then being told you can't work for a competitor or start your own business in the same industry for a certain period after leaving. That's what a non-compete agreement does. These clauses are common in many employment contracts, but their effects go far beyond just legal words. They influence workers, employers, and the whole labor market in ways that are often overlooked. Non-compete agreements mainly limit how freely workers can move between jobs. They can prevent employees from accepting new jobs with competitors or starting similar businesses for a set time after leaving. These restrictions can last anywhere from a few months to several years and usually cover specific geographic areas or industries. Not just high-level executives or specialists are affected. Even entry-level workers might be bound by these rules, often without much say in the matter. From a worker's point of view, non-compete agreements can reduce their ability to find better paying or more suitable jobs. Because they can't work for competitors or start their own business, they have less leverage when negotiating wages or benefits. This can keep wages lower and limit job options, especially for workers in lower wage roles where the restrictions are less justified. For employers, non-compete agreements are meant to protect trade secrets, client lists, and proprietary information. But they can also have downsides. When employees are restricted from moving freely, it slows down the transfer of knowledge and reduces competition among companies. This can make innovation slower and the labor market less dynamic. Some businesses relying on other legal tools like non-disclosure agreements or non-solicitation agreements that protect their interests without stopping workers from moving around. Laws about non-compete agreements vary a lot depending on where you are. Some states have strict rules or even bans, especially for workers earning lower wages. Recently, the Federal Trade Commission proposed a nationwide ban on non-compete clauses for most workers, except for senior executives. This move shows growing concern about how these agreements can hurt workers and limit competition. Legal disputes over non-compete agreements do happen, but they are not very common compared to how many agreements are signed. When disputes do happen, they usually involve former employers trying to stop workers from working for competitors. Sometimes, the threat of legal action alone can make workers hesitant to take certain jobs, even if the agreement might not be enforceable. Overall, non-compete agreements can reduce workers' ability to move freely, lower wages, and slow down innovation and competition. While they do serve some legitimate business interests, laws are shifting toward more balanced approaches. The goal is to protect business secrets without unfairly restricting workers' rights to find new employment opportunities. As laws continue to evolve, expect to see more limits on how and when non-compete agreements can be used, especially for workers who don't have access to sensitive information or decision-making roles.